Hi, I'm Bob Herbert. Welcome to OpEd.tv. There was a time, not that long ago, in my lifetime actually, when a woman could be denied a job simply because she was physically capable of becoming pregnant. There was a time when a Supreme Court justice could declare, "I will never hire a woman clerk," and make it stick. There was a time when blatant and grotesque harassment in the workplace, including unwanted touching, kissing, and worse, was expected to be accepted by women as a compliment. They would have no legal recourse. The term sexual harassment had not even been coined. We'll talk about all of this and about the many long, hard fights against these outrages with my guest, Jillian Thomas, a senior staff attorney with the Women's Rights Project of the American Civil Liberties Union and the author of a compelling new book, Because of Sex: One Law, 10 Cases, and 50 Years That Changed American Women's Lives at Work. Jillian, welcome. Thanks so much.
Thanks for having me.
Congratulations on your book.
Thank you.
Because of Sex is a provocative title, but it's really about those three words being added to one of the most significant pieces, historic actually, pieces of legislation in American history. Tell us about it.
That's right. It's the 1964 Civil Rights Act, which we all rightfully know as the real culmination of decades of agitation for civil rights equality for African Americans, and it addressed all aspects of American life for African Americans. But Title VII, the provision that dealt with employment, also added different classes, including national origin, color, and religion. And in the final days of debate, the protection, discrimination because of sex was also added, but very much at the last minute.
And how did that come about? I mean, who added it and why?
Well, women's rights on the job certainly had been in discussion for really decades, and of course the prior year before the Civil Rights Act was passed, the Equal Pay Act had been passed, but most women's advocates had been saying, you know, this bill is about race, let's wait on sex. But Congressman Howard Smith, who was very, very conservative, a segregationist from Virginia and was against the Civil Rights Act, was also somewhat incongruously a supporter of the Equal Rights Amendment, which some members of what you would call the feminist community in 1964 supported, not all of them. It was really a divide, frankly, that you see a lot in the feminist movement throughout history, of sort of more well-off women and more kind of academic pleas for equality, and then women who are kind of on the ground, union leaders and so forth, who know what quote-unquote real women are going through. In any event, that split was evident here, and the ERA supporters pressured Smith to propose sex as an amendment, primarily because they were afraid that black women, by virtue of their race, would get more protection on the job than white women.
Because the Civil Rights Act protected blacks, and without a specific protection for women,
Correct.
Black women might be in a better position.
Correct.
There was sort of, and I don't know whether it's true or not, there was this idea that came down over the decades that this provision of Title VII was put forth in an effort to undermine passage of the Civil Rights Act. Was that true or not true?
Right, the so-called poison pill that congressmen might be willing to support equal rights for African Americans, at least on paper, with images of Bull Connor and Birmingham on the television screen, but they wouldn't support it for women. And so that's the story, that Smith added sex in an effort to kill the bill so that people would vote against the sex provision. Historians have delved more into the history of this particular kind of blip, which it really was in temporal terms, blip on the passage of the law, and they have come out more thinking that it was more likely motivated by a feeling of that it would be unjust to black women, that he really did have some genuine concern for the rights of white women, white women specifically, and that was his aim. Others are even more cynical, that he thought that this law would invalidate some of the state laws that imposed so-called protective laws on women, which restricted their ability to work as many hours as men, in all the same jobs as men. And so his business interest friends could have also been happy to have those laws struck down.
So we're talking about the 1960s here. Could you talk a little bit about what the workplace was like in general, in a general sense, for women in, let's say, the mid-1960s?
Very, very segregated. It's, the show Mad Men has offered a lot of illustrative examples in talking
Life
about
really
this book.
was like that.
Yeah. I mean, at least if you were lucky enough to be in an office, of course, there were lots of women, especially women of color, toiling much farther down in even lower status jobs than secretary. But at the time, women's options were really pretty few. It was, secretary, nurse, teacher, waitress, clerical kinds of workers, and then, as I said, on down to, housekeepers, laundresses, things like that. And men had access to not only the kind of executive suite sorts of jobs, white-collar jobs, but also the very good-paying, unionized so-called blue-collar jobs, which, as I mentioned, those protective laws, which had been put in place really in all 50 states to regulate which jobs men could hold and women could hold, they had really done a number on the workforce and segregated it. So we had want ads that were divided at the time of Title VII and for years after into help wanted men and help wanted women.
I remember that was just common. It was accepted by most people as, they didn't see anything strange in that.
Right.
There were all kinds of what we would think of as bizarre restrictions. So flight attendants who were, I think they were all women in those days, but they were called stewardesses.
Sure.
They couldn't be married, but you would not have the same kind of restriction against pilots, for example. Pilots could be married. Yeah. What's the point of saying that flight attendants can't be married? Do you know?
Oh, I think that it was, and I think airline executives were quite blatant in justifying it, in saying that they served a role that was not just a safety role, but it was a sort of, wife or girlfriend in flight. They were there to be entertaining for the businessmen who were, flying around for their various business matters, and the women were there to fluff pillows and freshen drinks and light cigars. And if a woman were married, her husband would not be very happy about her being in that role, the airlines figured, and B, she would not be nearly as appealing to the customers. And that also extended to bans on how much weight the women could gain, and certainly pregnancy as well. So it's no surprise that when Title VII, that's very much sort of part of this man's world and women's world, and you're right. There weren't any male flight attendants, but those were some of the first cases that were brought forward after the Civil Rights Act was passed.
Now, that provision of Title VII that refers to because of sex, it protected women against discrimination, but not in all instances. There was something called a bona fide occupational qualification. What was that?
Right. We'll call it the BFOQ for short. And it was an exception that was carved out of the law, saying, employers are no longer able to discriminate on the basis of sex in terms of salaries they pay, whom they hire for jobs, setting the terms and conditions of work. But there's this one exception that if an employer can show that sex is a bona fide occupational qualification for a particular job, meaning only a woman can do this job, or only a man can do it. Not that most women can do it better and most men can do it better, but absolutely if you need a woman or you need a man for a particular job, then that kind of discrimination would be considered proper. And it's really fascinating because, there was no BFOQ written in for race. So right from the beginning, you have this congressional kind of crossing their fingers behind their back saying, we're here for equality, but there are also some instances where we're going to recognize difference in a way you would never say that there are some jobs that only blacks can do and some jobs that only whites can do. And so the BFOQ exception was what was at issue in those flight attendant cases. And in fact, eventually a man won a case to become a flight attendant. The airlines were not able to show that being a woman, only women could fluff pillows.
Yeah, the argument was that only women could do this job, were qualified to do this job.
Well, and the job was really safety, right? The airlines tried to make it about pillow fluffing, but it was about, can you get someone out of the plane in an emergency?
Oh, my goodness. So you profile 10 cases, actually. So you talk about the experiences of several women who actually decided to pursue legal challenges, whatever the consequences, and there were, in fact, consequences. We don't have time, regrettably, to go through all of them, but talk about 2 or 3 of these cases.
I really did come to love all the women who, for the most part, had no idea that their cases would end up at the Supreme Court. So that was...
You never know you're going to be part of history,
No,
right?
you think I'm just calling a lawyer to try to get my job back, and suddenly, 8 years later, you're in front of the 9 justices. So that's definitely one theme of the book. But the book sort of breaks down around 3 themes, I think, of which the cases are illustrative. The issue of motherhood and pregnancy and the barrier that has posed and continues to pose to women, and how the law has dealt with that with working women. The issue of stereotypes, you sort of alluded to it with the notion that there are certain jobs that women just can't do or don't want to do, aren't suited to do. And then, as you mentioned in the introduction, sexual harassment, which didn't have a name even in the 1960s. It was just the way things are. So, I think really the very first case in the book, the Ida Phillips case, Phillips v. Martin Marietta, is a case about a woman who was a mother and was denied employment because she had a preschool-age child at home and she wanted to be on the assembly line at Martin Marietta. And the company felt that mothers of young children were inherently unreliable. They took more phone calls at work. They were distractible. They would be late or have more absenteeism.
As opposed to fathers of young children.
That's right. So you have, and so in fact, you had the company, making a quasi BFOQ argument that women are inherently, or at least women with children, are inherently unsuited for this job. What was also interesting in that case, though, was and why one reason it's in the book is because of the definition of what is sex discrimination. Because the company came back to Ida Phillips and her lawyer and said, well, how can we be discriminating against women? 70% of our assembly line is women. So we don't discriminate against women. It's just this certain subset of women, the ones with small children. And that argument won at the district court level and at the appeals court level. And but there was a vigorous dissent at the appeals court level that I think caught the attention of the NAACP Legal Defense Fund and got their firepower behind the case when it went to the Supreme Court. Because even though Ida Phillips was white, the lawyers at LDF were able to see, gee, if you start, well, first of all, the majority of working mothers were black, so it was directly their constituency. But then also, if you start taking all of the protected characteristics of Title VII and carving out little bits of them, left-handed blacks won't be hired, or right-handed Jews won't be hired. You start making the law meaningless, and so you didn't have to be discriminating against all women to still be discriminating because of sex. And the court bought that, which was a big accomplishment in the very first Title VII case that the court ever heard.
Wow. And then there was a woman named Michelle Vinson who, and this has to do over all the years, one of the worst cases of sex harassment that I'd ever heard. But tell her story. Yeah.
And I should say at the outset that she's the one plaintiff in the book I wasn't able to speak to, who's still alive, who I wasn't able to speak to. She, I never heard a reason why, but she was not interested, I think, in dredging up that past. So I got her account from her attorneys and from court documents and from other people she'd spoken to. But this case arose in the late 70s. Michelle Vinson was an African-American woman of very limited background, grew up in Northeast Washington, D.C., and was very excited to get her first kind of white-collar job in a bank, the branch bank that she had grown up using. And her supervisor was Sidney Taylor, also African-American. The case has shades sort of the Anita Hill, Clarence Thomas situation later, albeit with far more brutal facts. And after she'd been there for about 6 months, Mr. Taylor, which she always called him Mr. Taylor even through the litigation, propositioned her and told her she owed him, and he also threatened her life, according to her, not just her job. And so she gave in, and she continued to give in over the course of about 3 years. She was really a victim of criminal criminal behavior, not just a Title VII violation.
They were actually having sex over this period of time.
Yeah, 40 to 50 times they had sex, frequently at the bank, I think mostly at the bank. And then also a panoply of other kinds of behaviors that everyone, I think, would understand to be harassing as well, touching and leering and so forth. He also directed that at the other women in the bank, and these other women spoke at her trial, and most of their testimony was disallowed by the judge, saying...
Which, if I can interrupt,
Yeah.
just gives a sense of the kind of extreme behavior that was going on in those days, and in most cases, no consequence for the men involved. But
No, that's right. There were some, the term sexual harassment was coined by some feminist academics at Cornell University in the mid-1970s. And around that time, lawyers did start trying to use Title VII to challenge this kind of behavior, this just the way things are kind of behavior. The earliest cases were the ones that were the most kind of obvious. Supervisor propositions subordinate refuses and supervisor fires subordinate. Pretty straightforward. And although they faced obstacles at first with these cases, and judges would say, well, this is just a personal interaction that's gone awry. This wasn't something that was connected to the employment relationship. This is something that was just personal between the two of them, so I'm not going to use a federal law to regulate dating, essentially. Finally, courts started seeing, wait a minute, if someone's actually getting fired or getting denied a promotion, if she's feeling it in her wallet that she's saying no, maybe that's discrimination. So by the time Michelle Vinson's case went to court, that at least had gotten some preliminary acceptance. The problem in her case was that she didn't face any, she gave in. She acquiesced, but
and her job was at stake. And
her life, if you believe her testimony as well, that she felt she was going to be killed. And but also she had a very sort of troubled background, no supports in her life. She was going through a divorce. That's actually how she got her lawyer, by the way, to fight the case. So she was in her divorce lawyer's office and started sobbing, and the divorce lawyer referred her to an employment lawyer. But so by the time the case got to the Supreme Court, the issue was on the table. Is there a legal violation? Is it discrimination because of sex? If just your environment is polluted, so you haven't lost anything out of your paycheck, anything tangible, but you've had to labor under conditions that a man would never have to labor under. And the court did agree to that. And it was a big help, ironically, that the EEOC had issued some guidelines in 1980. Her case was decided in 1986, had issued some guidelines finding that hostile environment harassment was sexual harassment. By the time her case came before the Supreme Court, Clarence Thomas was in charge at the EEOC, and he was not thrilled about submitting a friend of the court brief in her favor. So the commission split the baby. They said that hostile work environment harassment is discrimination, but that Michelle Vinson hadn't proved it in her case.
The idea of Clarence Thomas being in charge of protection for blacks and protection for women just boggles the mind. And then just one more really, I think, extreme situation. This was a case, I'm reading the book and I see where women are voluntarily becoming sterilized in order to keep their jobs. And this had to do with a company, I think, called Johnson Controls.
Yeah, a battery manufacturer, Johnson Controls, headquartered in Milwaukee. And like a lot of companies, a lot of manufacturing, big corporations, defense contractors and so forth, who worked with dangerous materials, around the late 1970s, they were being forced to hire more women. These are jobs that had been typically all male. So the government was really on them, to the Department of Labor and the EEOC, to hire more women. So they did, grudgingly. And then soon thereafter, they started enacting, including Johnson Controls in 1982, started enacting these fetal protection policies, saying that the materials that the company required people to work with, in Johnson Controls' case, lead to make batteries, was so dangerous to a developing fetus that they would prevent any woman who could not prove herself infertile. So it was not just someone who said, I'm done having children, I'm using family planning devices now, or someone saying I'm a lesbian and I don't have sex with men, or whatever the explanation for, you don't have to worry about my childbearing. The company said, we know better. And so any woman who could not prove herself infertile was banned from a job working with lead, which were the most of the jobs in the company and of course were the best paying jobs. So some women took the transfer to the janitorial job that was offered to them, but some, as you say, had themselves sterilized in order to keep earning that higher wage because they needed it that badly.
And this case also went to the Supreme Court.
Yes, yes. All the cases in the book went to the Supreme Court, and it was another, just like Vincent, it was another unanimous decision. The court basically said, even if this job is dangerous, it's up to women to decide what risks to take on in the workplace. It's not up to employers. And that regardless of how dangerous a job is, that's a choice for the individual woman to make. They also noted, of course, what was true, which was that lead was equally, if not more, harmful to men's reproductive systems as well, and men weren't being subjected to this.
Right.
And I need to correct myself. I don't think that was unanimous. I think the reason I was thinking it was noteworthy, however, is that Justice Scalia, of all people, whom we know is very pro-life and very protective of reproductive life, was actually in the majority and believed it was true that that women should be able to make these decisions.
Right. So Scalia was on the right side of the issue.
He did write a concurring opinion, making plain that he would allow some limits in some cases.
Now, so this book is about the Civil Rights Act, which nearly everybody realizes is historic, but they think of it in terms of historic because of the benefits to African Americans. But it was also historic because of the benefits for women.
Right.
Which brings us up to the 21st century now. The situation of women in the workplace has changed profoundly, but there are still challenges. Can you talk about what it's like now, and what these challenges are, and what's being done about them?
Sure. The reason I wanted to write the book is partially a celebration that because of Title VII, women were able to enter every aspect of the workplace, no matter how blue collar or how white collar, rise to the highest level, do construction work, do firefighting, whatever they wanted. That's at least what the law provides that they're able to do. And so as a result, we see that women are half the workforce. Women are working till their 8th or 9th month of pregnancy. 70% of mothers are in the workforce. So that's a huge change. What hasn't changed, as you alluded to, are a lot of the same problems that were at the source of these cases, and they either persist in new forms or just persist maybe under the level or even unconscious. So, sex segregation of the workforce still persists. Women are clustered in low-paid jobs, which is a huge contributor to the wage gap. Plain old vanilla discrimination is a cause of the wage gap. Lack of pay transparency, and that's less a sort of legal claim unless the law is changed, and more a policy that employers have adopted of not letting anybody talk about their pay. So that's a mix of kind of policy and legal problems there. Obviously, there's discrimination if women are trying to get into male occupied positions and are being still directed to the low-paying feminine ones. I feel that pregnancy and motherhood remains the greatest barrier to women's equality in terms of stigma against mothers and their commitment to jobs. The lack, again, this is a mix of policy and legal solutions, because the lack of paid leave, lack of good paid childcare, are enormous barriers. I mean, the idea that only 12% of private sector employees in this country receive a single day of paid leave. Wow. I mean, over 80% of private sector employers have no paid leave when they have a child.
So there is still a great deal of work to do.
Yes.
I have more questions, but we've run out of time, unfortunately.
Okay.
Jillian Thomas, the book is The Cause of Sex. Thank you so much.
Thank you.
We'll be back in a moment with a final word. Back in 2002, I wrote a column for the New York Times about the warning from scientists that global warming was already attacking the world's coral reefs. This was extremely alarming because the coral reefs, sometimes called the rainforests of the oceans, support an astonishing variety of plant and animal life. Dr. Michael Oppenheimer, a climate change expert at Princeton, said they're the richest ocean ecosystem, and if they're destroyed or severely damaged, a lot of biological diversity simply vanishes. Coral reefs are breathtakingly beautiful, but they thrive in water temperatures that are only slightly below the maximum temperature at which they can survive. There is hardly any margin for error. So global warming is a mass killer of the reefs. And sure enough, just a few days ago, the Times reported that the Earth is experiencing only the third mass assault on the reefs ever recorded, and this time may be the worst ever. The destruction of what the Times calls this crucial incubator of the ocean's ecosystem is a monumental tragedy. But despite the Times story, it won't get much attention. And there is very little will here in the United States, or around the world for that matter, to do anything substantial about the human behavior that is the primary cause of this catastrophic warming. That's all for now. See you next time.